Good morning, Council. Can you see and hear me okay?
Judge, I can. Can you hear me?
I can, Mr. Brooks. Thank you. Ms. Cluck, can you see and hear me okay?
I could, Judge. I've lost you.
Okay. We can see and hear you pretty well.
Okay, I'm just getting a join a meeting screen, so let me see what's going on.
Yes, ma'am.
Okay, thank you.
Judge, on my screen I have welcome. Please wait. The proceeding will begin shortly, so I'm not sure what's going on.
Do you want me to put you in the waiting room and bring you back in, and maybe that'll reset your system?
If you will, please.
All right, let me try that.
It's just there twice.
Okay, Judge, can you hear me?
Can't hear you. Can you see and hear us?
Yes, I can. And I have Mr. Locker in the office with me because my office failed to notarize him, my office failed to call him and tell him that the meeting would be by Zoom. So he's in the office with me and beside me, Your Honor.
Okay. All right. All right, Council, are we ready to begin?
Yes, Your Honor.
Yes, Judge.
All right. This is cause number FM20-00298 in the matter of the marriage of Patsy Wygal and Michael Locker. I believe we're here today, Ms. Cluck, on a couple of your motions: motion to compel discovery, motion for sanction, and motion for additional temporary orders. Is that correct?
Yes, Your Honor.
All right, I've reviewed each one of those motions, so I think what would be the most efficient is to allow Mr. Brooks to respond to the let's respond to the motion to compel discovery first, Mr. Brooks.
Judge, yes, Judge. I'm not in disagreement with Ms. Cluck's recitation in her motion. My client at the 1st of December became COVID-19 infected and was basically just released last week. And so we've had a little bit of an issue going through there. We actually spent yesterday several hours and I've sent all the discovery to her, and I believe that most of the discovery that Ms. Cluck is asking for, we will have it to her by Friday. The production will have to be mailed because it's a little bit more voluminous than I can just download and then send to her. Or I'll be able to get the rest of it to her. Again, we apologize to Ms. Cluck and to the court, but like I said, she had COVID for 19 for that almost a month and was kind of hard to deal with it. And she's really not even released to go back to work yet for another 2 weeks. So that's why we'd like to try to get that done and get it over with. I mean, I'm sorry, Ms. Cluck is right on that issue.
Ms. Cluck, go ahead.
Yes, Your Honor. I have not received any of Mr. Brooks. He stated that he's produced some discovery, but I haven't received anything as of this morning. Any documents or any responses. So, and he says something about mailing part of it. So I understand that, and he understands that I haven't received that, but I haven't received anything as of this morning. The discovery was originally due like October. Well, he says he doesn't dispute that when the discovery was originally due. So it was originally due before Miss Wygal was ill. However, we still need the discovery, and so we need an order that orders a date certain, Your Honor, so that and hopefully all this will come in by the end of the week and by Friday. But we do need a date certain for that to be produced to us. And also, Your Honor, we because of the discovery, I mean, we will there are some timetables, as you've read in the motion, that need to be amended because we have not received a discovery as far as the inventory and appraisement. And of course, we haven't received Mr. Brooks' inventory and appraisement and or Miss Wygal's inventory and appraisement. And she is in control and custody and possession of almost all the records in regards to the marital estate.
Judge, just so we can be real clear, I'm sorry, I don't believe that I represented that we had sent anything. I said Ms. Wygal and I worked yesterday on getting that so we could have it to Ms. Cluck by Friday. I'm sorry, I don't want to make any kind of misstatements. We have not sent anything. We have it all ready to go. And we are in a dispute about who has the records. We believe Mr. Locker has the records based on the information, but that's for a later date. And Judge, I certainly don't have a problem with a date certain by when all this should be there. But if it goes out in the mail tomorrow, certified on the production, Rule 194s, interrogatories, the inventory, all that's going to go out as quickly as I can get Ms. Weigel's signature on it, because I think we're there on that part of it. So yes, I can get that to her very quickly. As far as extending any deadlines, we agreed on a December the 14th exchange of inventories at the temporary orders hearing. That's before any discovery is going on. I don't know that Mr. Locker really ought to have discovery. And I don't think he ought to have any extensions to do his inventory, because the inventories has nothing to do with what the discovery is. He already should have an idea. So as far as any extension, for 45 days is what they're asking for. I do disagree with that, because I'd like to get this into mediation, and believe you me, so would my client.
And Mr. Brooks, has your client provided her inventory and appraisement?
No, Judge, I have it ready to go. We ended up having to change some things yesterday based upon retirement numbers had changed from December to now, and I wanted to make sure we were accurate on the retirement numbers, because the two major assets of this marriage is really my client's retirement and a piece of real estate property that they own in Van Zandt County.
So neither petitioner or respondent have completed their inventory and appraisement.
Judge, I don't know where Mr. Locker is. I believe ours is complete. We just need to send it. We were working on all of that together yesterday.
Yeah, well, and Ms. Cluck, and Ms. Cluck had indicated that Mr. Locker has not done his, but she has indicated that she is going to be relying upon the responses to the discovery to complete the inventory and appraisement. Is that correct, Cluck?
Yes, Your Honor. When we came to court on October the 28th, I had served Ms. Wygal with discovery requests on the October 1st date. And so I knew that within 3 days, we should be getting that discovery. And I would be relying on that discovery to do our inventory and appraisement. Otherwise, I would never have agreed to a specific December 14th deadline. As Mr. Brooks has pointed out, his client is in possession of the retirement information. We certainly can't do any kind of inventory and appraisement without that information, and she is in exclusive possession of the information in regards to the pieces of real estate. So we are, this was our reason to agree to the inventory and appraisement and to the date in the first place, Your Honor.
Mr. Brooks, give me an idea of what you believe would be the best date certain for the production of the discovery that Ms. Cluck's requested.
Judge, I believe that based upon what my client has informed me yesterday, there will be documents delivered to my office today. And then as soon as those can be incorporated into the production responses, they will go out in the mail no later than tomorrow, which would be Thursday. And so however fast the United States Mail can get them to Ms. Cluck is how quick she intends to have them. Again, my client has sent this morning 1 or 2 little changes on the interrogatory questions that we'd worked on all day yesterday with her unsworn jurat, because I don't, again, have a notary in Van Zandt County. And so I believe that by tomorrow, I'm going to have the inventory out, interrogatories out, Rule 1. I believe everything goes out no later than tomorrow, and hopefully by today, if I can get it done.
All right. What the court's going to do is I'm going to order that discovery be completed, that Ms. Cluck receive her discovery responses on or before, and I'm going to give the U.S. mail a little longer than I anticipate it would take pre-COVID. I'm going to give them until January 22nd That's a week from Friday by noon. That would be the date certain. And on the inventory and appraisement, I'm going to give each party 30 days from that 22nd date. Let's just call that, look at my calendar here. Let's say inventory and appraisement completed by both parties, February 26th by noon. Do you, each of you believe that you can work within those parameters?
Judge, I know we can, and I again apologize to the court and Ms. Cluck, but we will have ours out this week.
Ms. Cluck, do you want to argue your motion for sanctions, or do you want the court to table that until we get some kind of response on the discovery?
I would ask that the court table that until response to discovery, Your Honor.
And I'm sure, Mr. Brooks, you have no objection to that.
No, Judge, we appreciate the consideration of Ms. Cluck. Thank you.
Okay. All right. Is there anything else we need to address then today? So we've got a date certain for discovery responses, January 22nd, 21 by noon, and inventory and appraisement by both petitioner and respondent, February 26th by noon.
Yes, Your Honor, there is the additional matter. We, pursuant to the temporary orders, we agreed, there was an agreement for Ms. Wygal to pay spousal support on the first of each month through January. And then that in the event that the divorce would not be completed by the end of January, that Mr.
Locker.
Yeah, I'm sorry, that Mr. Locker would could come back to and request that the spousal support continue. And so we're asking that that continue and until final trial, Your Honor.
Mr. Brooks.
Judge, we certainly, I think the court would understand that pursuant to the agreement, my client is paying roughly $2,000 a month in temporary spousal maintenance, and that's an incentive for her to try to get this thing moving. We certainly would object until final trial, in that we've now moved out inventories to the 26th. We got to do mediation in this case. We'd like to get that set, and I'm sure Ms. Cluck probably does not want to mediate till she's gotten her inventory from us. We certainly don't need the inventory from her to get mediation, and we're trying to get this over. We believe that Mr. Locker has sufficient funds to care for and provide for his needs between now and the end.
On the temporary orders hearing before, refresh my recollection on, did the court order spousal support until final trial, or was it a date certain?
Judge, there was an agreement by the parties that we would pay until the 1st of January. And as Ms. Cluck has correctly stated, at the time that we presented the agreement to the court, we agreed that in the event we were not finished, there would be no objection to coming back and asking the court to conduct a hearing to determine if there should be additional support paid or more time paid.
Your Honor, pursuant to the, Mr. Brooks was wanting to limit the payment of the spousal support. And we're back where we started, Your Honor, back in October the 28th. So and pursuant to our agreement and to the order, we had the right to come back and request that this spousal support continue until based on the fact that it wouldn't be concluded by January. And so we're back where we started as far as October the 28th. We have a difference of Mrs. Wygal's receiving over $11,000 a month. Mr. Locker's receiving $2,000 a month. So we have a $1,400 a month. I'm sorry, Your Honor. So we have a major difference, and he's $1,400 a month versus $11,000 a month is a major difference. The only reason we agreed to limit it or to set it for January, and then we could again request the court to continue it, was because we were trying to get it resolved speedily.
So the court has not received the evidence regarding what Ms. Wygal makes versus what Mr. Locker makes. Rather, it was an agreement between the parties at that time. Is that correct? So the court has,
Yes, Your Honor.
Yes,
court
Judge.
has not received. And so now you're telling me that the agreement, that each side, or that Ms. Weigel does not want to continue the agreement, and obviously Ms. Cluck's client does. So do we need to set this for a hearing?
Judge, it's set for a hearing today. Ms. Cluck's office filed the motion and amended their notice so that it could be considered today. I'm not trying to say Ms. Cluck hasn't given notice of that. She has.
Your Honor, this order specifically, the spousal support amount was already agreed upon by the court. Agreed upon by the parties, an order of the court. It specifically says, so the amount is not contested. The amount was there as far as spousal support. The consideration is whether it should be continued or not. And pursuant to the order, we had the right to request it to be continued. We're right back where we started. So we're just asking that it be that amount be continued. The temporary order says the amount, and the temporary order says that we have the right to request that it be continued.
Okay, let me go and review that order real quick. And
Thank you, Your Honor.
you said that was October 28th?
Yes, Your Honor.
All right, give me just one moment.
Certainly.
Could the court please put me in a breakout room? Never mind.
Yes, sir, go ahead.
I was going to ask to be in a breakout room with my client and maybe to visit with her a little bit about this issue.
Yes, sir, give me just one moment. I'll create that for you.
Thank you, sir.
Mhm.
I lost her.
You know, Mr. Brooks, I don't see Miss Weigel anymore I don't see her in the meeting at all.
Judge, well, I'm going to mute myself and call her then. Thank you.
Okay, well, I'll tell you what, I'll go ahead, in case that she's there, I'll go ahead and put you in there, and then you can exit whenever you want, but
Thank you.
I don't see her at this time, but we'll go.
I know she was there just a moment ago. I saw her.
Okay. Yeah, she was here a moment ago. All right, Mr. Brooks, have you had an opportunity to speak to your client about this issue?
No, Judge, I've called and left a voicemail. I note that she was trying to log on or be participant via her phone from home. So I don't know what's happened to her at this point. I just know that she was here.
Do you believe that if given the opportunity to speak with her, you may be able to come to an agreement on this issue, or do you believe?
To be honest, Judge, I don't know. I can't give you an answer to that. I wish I could. Maybe,
Okay.
possibly.
All right. Well, let's do this. I know the time is 9:25. The court will stand in recess for 15 minutes
Thank you.
and give you that time, and then we'll resume at 20 till the hour.
Judge, are you going to put everybody in a waiting room or do we go out and come back? How do you work?
No,
that?
I would say just turn off your camera and turn off your audio.
Okay. Thank you, Judge.
Turn off your camera, and we'll just, I will stop the recording, and we'll just hold what we got.
Thank you.
You're welcome.
Thank you, Your Honor.
So we'll resume at 20 till the hour.
Thank you, Your Honor.
You're welcome. Counsel, are we ready to proceed?
Yes, Your Honor.
Judge, I saw my client come back in and then she's gone again. I talked to her and she said there had been a power, I guess, outage or something there, and her internet then went down and then came back. So I don't know if there's been something else that's happened.
Let's see. I see she came in earlier. I saw her. I put her in the attorney-client room. And then you're right, she left. And now I see a phone that's come in. Let's see if this is her. As she's coming in, have you had a chance to speak with her about the issue?
I have, Judge, and I had sent a message through the chat to Miss Cluck.
Oh, okay. Ms. Wygal, are you there? It shows that there is a phone number 903 N727.
That is the last 3 digits of her number. Yes, Judge, that is it.
All right, Ms. Wygal, can you hear the court? I should. Here's that same number. Let's try it again.
Let's try it again.
Ms.
Hello.
Wygal. Hello, Ms. Wygal.
Yes, I'm here.
All right,
Yes, I'm here.
Okay, all right. This is Judge Chris Martin, and we're back on the record in FM20-00298. Go ahead, Mr. Brooks. You said that you had sent a message to Ms. Cluck on the chat.
I have, Judge. There's not been a response yet. I don't know if Ms. Cluck's had an opportunity to see it or not.
Ms. Cluck, have you received Mr. Brooks' message?
Yes, Your Honor, I just received it.
Do you want me to put you two in a breakout room and let y'all have some?
Can you please, Your Honor?
Thank you.
You're welcome. Here we go. When you get the invitation, just accept it. Mr. Brooks, did you get the message to?
I haven't gotten an invitation yet, Judge. I'm watching the chat and the screen and everything, so I haven't seen that.
I moved you from, let's see, I'm gonna put you in the waiting room and bring you right back in.
That'd be fine. Thank you.
Maybe try to reset this system here.
Okay.
Yeah, for whatever reason, it is showing you that you're in room 2 where Miss Cluck is, and I don't have any other ability to select you at all. This thing's been finicky as of late. All right, council, have we had enough time to discuss amongst yourselves?
Judge, we have, but I had to leave the breakout room to come back and talk to Ms. Wygal because I couldn't communicate with her from the breakout room. I need to visit just momentarily again with Ms. Cluck. I'm going to send her a chat to let her know where it's at so we all don't leave again. Is that okay with the court?
Yeah, that's fine. That's fine.
Thank you.
Are you able to contact Ms. Weigel by chat also?
I spoke with her by chat, Judge, before I'm talking to Ms. Cluck, after I'd spoken with Ms. Cluck.
Okay.
I apologize for my typing skills.
No problem. I'm sure they're better than mine.
Did you receive it, Ms. Cluck? My message?
No, I haven't.
I sent via the chat, so it's gone.
Are you counsel ready for me?
Yes,
Yes,
Judge.
All right, we're back on the record, FM20-00298. Go ahead.
Your Honor, we've reached an agreement to extend the spousal support of $2,000 a month for February 1st and March 1st. We're going to try to get the case mediated no later than March, or February no later than March, in the event that with the support to be continued at the request of the respondent again in March in the event that we're have not resolved, don't have a final resolution.
Do the parties have an agreement on the mediator?
Yes,
Yes,
Your
Judge.
Honor. It's in the temporary order. It's Steve Watkins, Your Honor.
Okay. And do we have a mediation date scheduled with Mr. Watkins?
Not yet.
Do we have a mediation deadline date?
No, we don't, Your Honor.
Do we want to get one today?
I would like one. Yes, Judge, please.
That's fine, Your Honor.
Okay. And so do you,
If
go
I
ahead.
may, Your Honor, Mr. Brooks had said he contacted Mr. Watkins and he had dates in February, but I've checked my calendar and those don't work. But surely we can get other dates, and especially in March if we can't find other dates in February. And I'm sorry for
I
interrupting
believe
you.
so too. I believe so also, Your Honor.
That you can find a date, an agreeable date in March?
I believe we can.
Yes,
Do
Your Honor.
you want me to give you a date, or do you want me to let you two work on that together?
That's up to you, Judge.
It's up to you. I think we can work it out, really.
Okay. All right. Well, I'll leave you with that then. So the court will see amended temporary orders to include additional spousal support for February and March. Is that correct?
That's
Yes, Your
correct.
Honor.
Okay. All right. And then we'll also see an order with the discovery dates of January 22nd, 21, and inventory and appraisements February 26th by noon. Is that right?
Yes, Your Honor.
Okay. All right. As soon as the court sees those orders, I'll get those signed and circulated back.
That's fine. Judge, I have a question. I haven't received a conformed copy of the temporary orders, and every place is different. Do y'all normally send them back out with the e-file when the party's there? I'm not arguing about them. I'm just trying to figure out, make sure I'm getting the right process to get my copy.
Usually, my understanding is once the court signs it and it goes back to the clerks, then a conformed copy is sent back to the parties. Ms. Klug, do you have a different experience?
No, that's been my experience, Your Honor, that each lawyer gets a copy of the of it when it. So I will be glad to provide Mr. Brooks with it.
That's fine. Thank you, ma'am. I'll reach out to the clerk and make sure that my address and everything is correct there, Your Honor, though, because I'm sorry. When I got going through this yesterday, I didn't find one. I said, oh, what have I done wrong here? And so I just wanted to make sure I got a copy of one. Thank you.
Yes, sir. Maybe just double check your email address too with your e-file, but
I will.
you should receive a copy of that.
Okay. Thank you.
All right. If there's nothing further, then you may be excused, and appreciate you, Mr. Brooks, and appreciate you, Ms. Klug, for being patient today while we work through our Zoom.
No, thank you, court. Thank you, Ms.
So
Clark.
much, Judge.
All right. Thank you. We'll be adjourned.